Hello and welcome to the kickoff episode of Season 5 of ARBinBRIEF, your practical video guide on handpicked arbitration issues. ARBinBRIEF is produced in collaboration with Pledge, and Season 5 is sponsored by the Asian Case Management Center of the American Arbitration Association, ICDR. My name is Vanessa Meirelles Schilling. I am part of the ARBinBRIEF team and a Brazilian and Portuguese qualified lawyer practicing international arbitration as senior associate at Luther in Hamburg, Germany. I have the pleasure of moderating today's episode on multilingual arbitrators, challenges, and aspects of arbitrating in different languages. We will explore how languages shapes communication, persuasion, and fairness in international proceedings, and we'll not only address bilingual proceedings, but also all the challenges that are involved. Our focus is on the arbitrators and their experiences in proceedings, conducting hearings, drafting awards, and deliberating across linguistic and cultural boundaries. Our discussion today features 4 incredibly talented arbitrators, professionals who bridge the different cultures with their language skills in international proceedings. They are Ana Catarina Schäfer da Silveira, Carita Walgreen Lindholm, Dr. Galina Zukova, and Juliana Janku. Here's a very short introduction on who they are and their multilingual abilities. Ana Catarina is originally from Germany, but practiced in São Paulo, Brazil, at Adriana Bragueta Advogados. She arbitrates and advises in German, English, Portuguese, Spanish, and French. Carita is a partner at Lindholm Walgreen Attorneys based in Helsinki, Finland. She's also a former chair of the ICC Commission on Arbitration in the ADR and conducts proceedings in Finnish, Swedish, English, and French. Dr. Galina Zukova is a partner at Zukova Legal in Paris. She's an independent arbitrator and academic and conducts proceedings in English, French, Spanish, Italian, Russian, and Latvian. And Juliana Janku is a partner at Hanotio Thorstens Goldman in Brussels, Belgium, focusing on investment and commercial disputes. Being originally from Romania, she conducts arbitrations in English, French, and Romanian. To start off, I'd like to ask each one of you briefly to tell us about a little bit about you and a little bit about your multilingual background and how did it become part of you of your arbitration practice. Maybe we start with Carita.
Thank you, Vanessa. Well, I guess sometimes it's an advantage not to have too many choices. If you grow up in Finland, where the language itself is rather insignificant internationally, and then as within that country, you also are part of the minority population representing like 5 to 6%. The majority language is Finnish and my minority language is Swedish. Then you have to open up to the world. So before I went to law school, I majored in French and minored in English. And then in the progressive north, I couldn't land a job in a law firm in Finland because I guess I was too much of a nerdy girl. So I went to Paris, where I started working in international arbitration with Chris Seppel and Eric Schwartz, who I'm sure that many of you know. And then I guess that
Can I just ask a little middle question? Did you go to Paris to work with arbitration, or did arbitration just happen because you were in Paris?
No, I went because I wrote my thesis on, not doctoral thesis, but my thesis in law school on ICC awards. And I met there was one council at the ICC, and they had their first seminar in Finland. And as a student, I got a free spot. And then he said, well, since you're well versed in French and English, why don't you apply for a job in France? So the rest then happened and is history, I guess.
I see. Maybe Anna, can you tell us a little bit also about, I think you both share a part in the ICC of your
Yes,
background.
sure. Thank you. Thank you, Vanessa, and hello, everyone. So, contrary to, I think, some of my co-panelists today, I did not grow up in a multilingual environment, actually. I went to a traditional German school in Germany, but I was extremely interested in being able to understand and communicate in other languages from a very early age. So, in school, I decided to study English, French, Spanish, and last but not least, also Latin, which is very helpful. So after that, I already knew I wanted to work internationally. And nonetheless, I decided to first study law in Germany, create a basis there. So I eventually became a German qualified lawyer and started working in a German firm. At the time, primarily in really domestic German court litigation cases, which I still think is a great basis for what I do nowadays, because I think even working abroad, I will always be perceived as the German qualified lawyer. After 2 years in that firm, I looked for a more international work and eventually had the opportunity to join the ICC, where Carita also has a strong connection to, and worked as a deputy counsel in ICAT 3 in the German team at the ICC, where I worked primarily in English, but also in French and sometimes in Spanish. And of course, I was working in a very, very international environment, surrounded by people of all nationalities, speaking many languages. So I enjoyed that very much. A couple of years later, I got an offer from a Paris-based large law firm to be working as an associate in their arbitration team, which was also an amazing experience, I have to say, because they also worked with people from all over the world, speaking various languages. At the time, in my cases, I primarily worked in English, but the cases typically involved also witness evidence or documents in other languages, which was really a great experience. And then now it's been 6 years that I've been living and working in Sao Paulo in Brazil. So to be honest, very much further away from my home than I would have imagined at the beginning of my career. But as you know, the arbitration market here is booming. It's a very, very interesting place to be working at. I first worked in a larger firm here in Sao Paulo in Brazil, primarily still in English, but then I had to learn Portuguese very quickly to master everyday life here, but also to be able to eventually work in a lot more cases, because the market, as big as it is, it's still quite domestic, one can say. Even if foreign interests are involved, a lot is happening in Portuguese. And nowadays I work in a smaller firm, also with the idea to be working more as an administrative secretary and eventually as arbitrator. And I'm able to use all 5 of my languages, which is a great privilege. That said, being based in Latin America, nowadays I work primarily in Portuguese, Spanish, and of course in English.
Good. Thank you very much, Anna. Also, Kalina, how did you, in your
my story?
multilingual background, come about?
Thank you, Vanessa, and thank you for the invitation to be here. It's very inspiring, very interesting to hear the stories of my co-panelists. So, as to my background and languages, I was born in a Russian-speaking enclave, but in the most Latvian part of Latvia, so to say. So, first of all, like even this Russian-speaking enclave, we had people from all over the Soviet Union, so all nationalities were there. I did my school in Russian, but I did my musical school in that city. And musical school in those days, it meant at least 4 days a week. And the musical school was very much Latvian school. So I think like this is where my exposure to Latvian started. And then we regularly had to travel to visit my brother family in Belarus and in Ukraine. We used to go through Lithuania. So I think, my ear was attuned to different languages from very early days. And I think like in this respect, again, I'm very much like a typical Eastern European in this regard, like crossing borders all the time. And then it came English kind of easy, like school, work. I was working for the Latvian government. I was working for European integration. This is when French was considered to be important. I lived in Italy. I live now in France. Spanish came because, you know, life goes on and you meet someone with whom you speak at home in Spanish exclusively. And this is how it is. So this is my story of languages.
Wow. That's also all different influences from different parts, the languages coming into your life.
Exactly.
Juliana, can you tell us also a little bit about how did you
Sure.
start working with different languages?
And thanks again for the very kind invitation, Vanessa. I'm also very excited to be here and to learn about the very inspiring stories of my fellow panelists. I think like Ada Katarina, I'm also from a monolingual environment. At home, everyone spoke Romanian. In the part of Romania where I'm from, which is close to the sea, there is some minority language being spoken, which is a version of Turkish. But I had no exposure to that. So essentially, my exposure to foreign languages came from TV as a young child in post-communist Romania. We had access to television without any form of subtitles or any other translation. So we heard in our house English, French, Italian, Spanish on TV on a regular basis because there was very little quality TV in the early 90s in Romania. That's something only someone from a post-communist state would understand the specific context of that. And then also because Romanian, honestly, the usability of the language ends when the border, when you cross the border, all children had to learn at least 2 foreign languages in school. And that was from a very early age. So in my case, that was English and French. But my education when I was working in Romania was only in Romanian. So my law school degree was in Romanian. I started encountering English and French professionally when I was working as counsel at a law firm in Bucharest, and I had my first arbitrations at the ICC. They were in English and in French, and I found arbitration to be very interesting, and the fact of being able to use the languages that I had studied in school also very exciting. So I pursued an LLM at Columbia Law School in New York. And here again, I think one aspect, I'm tying to what Carita was saying with respect to the humility that you have as a non-native English language speaker. I recall distinctly in class how all of us were the foreign students would speak less than our American counterparts, because we always had to double check and triple check in our minds that what we said was to the point and precise and correct. And, you know, it really conveyed what we wanted to say. So I suppose working in a foreign language gives you a little bit that advantage, that you have to be sure that whatever you say is as precise and as to the point as possible and free of artifice and flourishes that sometimes happen when you're expressing yourself in your native language. So I should also add, I'm sorry, now that I'm based in Brussels in Belgium, where well, Brussels mostly is French speaking. There are some Dutch speakers here, but mostly I would say that it's French speaking. And then at the law firm that I'm working at now and the previous one, it's always been a very international environment, from people coming from Australia, India, Colombia, the Philippines, and many other nationalities.
That's great. Thank you all very much. I think maybe we now dig into a little bit about your individual experiences. Anna, can you tell us a little bit about how it is to work between Brazil and Europe? So how do you approach cases where cultural and linguistic nuances influence the parties' communication and perception of neutrality?
Sure. So I think what's really crucial is that you do not only speak other languages or understand other languages, but that you're actually aware of the legal cultures, of the cultures that are behind those languages. So oftentimes what happens in arbitrations is that especially legal terminology is translated, but the translation does not really reflect what parties mean to communicate. So especially as an arbitrator, I think it's of really absolute importance that you are aware of that and that you take the necessary steps to make sure that everybody's on the same page, that parties understand what we're addressing, be it already in the terms of reference, PO1, and then later in procedural decisions and eventually the award. And I want to give you an example to illustrate really what I mean by that. So here in Brazil, we have a participant in the arbitration that's called the assistente técnico. If you translate that directly, that would be the technical assistant of a party. And oftentimes that's for instance, in terms of reference or in other documents, that's translated as party appointed expert, because party appointed expert is the more commonly used expression in international arbitration. However, a party appointed expert is not the exact same thing as the assistente técnico. Of course, there are overlaps, but generally speaking, an assistente técnico works in cases that involve also a tribunal appointed expert, because there is an exchange between those assistentes, those party appointed assistants, and the tribunal appointed expert. And also they're more perceived as forming part of the legal team of a party. So typically, and again, I say typically because nowadays there are exceptions to that, but typically those assistants, they do not sign a declaration of independence and impartiality, for instance, right? So it's really another figure in the arbitration. And as an arbitrator, you need to be aware of that and potentially take the necessary steps to make sure that everybody understands while maintaining neutrality, of course.
Okay, that's very interesting. I did not know that they do not sign a neutrality and independence declaration.
Again, typically they don't do that. Nowadays we see exceptions, but I think ICC Brazil is soon going to issue a report actually involving questions of expert evidence, and we're addressing this issue as well. So that may be an interesting read.
I see. Maybe we turn to Carita. You've arbitrated in 4 languages across the Nordic and international contexts. What strategies help you maintain precision and consistency when moving between languages? Do you also have examples of such as the one from Anna?
Well, I guess as a student of linguistics in a former life, the concept of language is very interesting. And I remember as a young person with a scholarship to the US, they often asked me what language I dream in, or do I translate, and all this. I couldn't really understand the questions because I grew up in a bilingual family. And I always thought that you speak the one language, you kind of go all in. It's not like you navigate between them, but you actually, I think your gestures are different. Finns are much more closed like this. The Swedes are much more open. So your whole persona also, I think, is affected by the language. In France, I was considered very shy, which certainly they wouldn't say in Finland, where they think I could use less words. So when you say that, I think that when you do something in a language, you absorb the totality of it. But there was something interesting that Anna Katarina thought that I'd actually like to tag on to, is the fact that I don't think is addressed enough, is that not only that Latin is important, but it's the complete package of legal culture and culture, and the humility. I use the word humility again, before different ways of doing things. We have in international arbitration, we have so many buzzwords, and people, they go to courses, they pick them up, let's do it like this and all this. But actually having a dialogue with parties, exactly what they mean, how to run things. I think as an arbitrator, your biggest task is to manage your listening skills and be courageous enough to ask questions and not be afraid when they say, oh, we all know how this works. I said, yes, maybe, but let's run it through once more what we actually mean. And I don't see enough of that. I'll stop here because
in international context, that is all the more important, because what one means with their own perspective and culture is maybe different from another perspective.
But Vanessa, let me just add this much. I remember when I was younger, now, of course, as a more senior person, people show sometimes a bit more deference and show you, give you the benefit of a doubt. But I think that when I used to ask questions, there was sometimes almost ridicule. Why do you ask that? We all know how this works. I said, okay, that's very good, but let's run it through once more to see that what we mean actually is the same thing for all of us. Thank you, Vanessa.
Thank you. That I think that comes a little bit also with as you say, when you're a little bit more experienced, that people then tend to give more deference to asking such questions. When we are younger, then it also, everyone looks at you like, how come do you not know this?
Yeah.
And when you're more senior, they don't assume that you don't know it. They're like, okay, then we're going to talk about it again. Yeah. Galina, maybe you can tell us a little bit about what about drafting awards in different languages? How does language influence the nuances of reasoning, for example? You're muted.
Yeah, I'm starting. One side observation as I was listening to Carita, I remember, as I said, I lived for quite some years in Italy. And then I moved to other countries, and when people from my past life saw me 5-6 years later, and they told me, they looked at me and was like, you speak much less with your hands now. And I'm not in that environment anymore, and you just adjust your body language as well, and you do it unconsciously, right? You don't think about it, but you do it unconsciously. As to the drafting of the award, how does this affect, this multilingualism, how it affects? I think, the assumption here, and I make an assumption for all of panelists here, if I'm wrong, please correct me, shout it out. But I think it's easiest for us to draft an award in English, right? It's just a matter of fact. So for variety of reasons, we can discuss those later. So if we speak about challenges in drafting a word in not native language and not in English, when we are speaking, again, in this setting, we are speaking about our third, fourth, fifth, or sixth language, something like this, right? So when we draft an award or work on that language, I mean, by definition, time will be longer, because I will be checking, that my language is correct, and I will be using, nowadays everyone is speaking about AI, I will be using AI for this reason, for languages reason, and I think, again, there is nothing wrong, I read perfectly, but when, I may like the expression in one way or another, when I'm giving these choices, so I can choose. I reckon the situation when I was sitting as a co-arbitrator in a case where the president took the case, but he was not really the language, his knowledge of a language of arbitration was not adequate. It was a lot of grammar mistakes. This made a comprehension of legal analysis impossible. And in that particular case, from one side, there was a good attempt to appoint an admin secretary, and there was an admin secretary, but even admin secretary wasn't perfect, right? So this was a very difficult experience for me, few agonizing months. So these are kind of situations you want to avoid, right? So I think when these questions also asked by the ICC, by other institutions, one thing is how many languages you can read, hear, understand, and in how many languages you actually can draft the award well, draft legal documentation, right?
There's a difference on
there is a major
drafting an
difference.
award
There
and
is a
sitting
major
as an
difference.
arbitrator.
There is a major
co-arbitrator.
difference, and again, Carita mentioned this word humility and modesty many times, but I think it's, when, I read German, I can follow German, I go to Germany and, to a taxi driver, I speak in German. but I never say I can write in German, like, and I will be not taking case as a president in German. So I think maybe again, between us, we are not afraid to say, like, I think we are critical, like what I can do, what I cannot do. But like some self-control is needed, I think, on people's side in this respect.
I see. I think we turn now to bilingual and multilingual proceedings where we have the parties do not choose one as the arbitration proceeding, but they choose to have all the time interpretation and simultaneous interpretation and translated documents. Juliana, can you tell us a little bit what are the practical challenges you see managing simultaneous interpretation and managing the flow of hearings in this type of proceedings?
Yes, thanks, Vanessa. So just to say that there's also cases where the parties haven't made the choice of language, and there's a discussion as to which language should be the language of the arbitration, and ultimately you can have a decision that it makes sense to have two languages as opposed to one. So it really depends on the circumstance. So I've worked on two, I would say, partially bilingual arbitrations, and by partially I mean that not every single thing that happened in that arbitration was conducted in two languages at the same time, which were English and French. So the parties could file submissions in either language they preferred. The tribunal would render all decisions in two languages, but communication by email would be done in just one language, just to make things efficient and fast. So I think there's a couple of things to bear in mind. It's not just the hearing itself that poses issues when you have bilingual arbitrations. So one issue can be finding an individual who can work in the two languages of the arbitration, but crucially, also meets the requirements of the case, meaning the applicable law, if that is a requirement to have someone who's qualified in that jurisdiction or someone who has expertise in the law of the seat, etc. You also have the various nationality requirements that various arbitration rules impose for presiding arbitrators, which can also complicate things, especially if one of the languages of the arbitration is not necessarily one that's very widely spoken outside of a given jurisdiction. That's one aspect. Another aspect, in terms of the hearing itself, as you mentioned, it really depends on the language, whether you can have simultaneous or you should have consecutive interpretation. You cannot generalize. Obviously, simultaneous interpretation gives the advantage of speed, but oftentimes the product of that interpretation can leave a lot to be desired. So you may have to revisit the transcript later on if you have a recording to make sure that what is actually interpreted matches what was said. And in one of the two cases that I mentioned that I worked on, actually there was a lot of difficulty finding consensus on the final version of the transcript, precisely because the two language versions weren't aligned. Another very important challenge, I would say, is to ensure, and that's for an arbitrator, that the two language versions of any one document have no contradictions and they're perfectly aligned. And this is something that takes a lot of time and effort, because a lot of the times you may have to go back to the document that you originally drafted. Say you first drafted in English and then you have to translate that document into French or vice versa, to make sure that you don't say one thing in one language and something slightly different in the other language. And this is particularly important for the dispositif. This, of course, all of this creates delays, creates costs. So you would have to ask yourself if it even makes sense to have a bilingual or multilingual arbitration. And another practical challenge where I think institutions can be very helpful is to find auxiliary personnel that is able to assist in a competent manner. So that means good quality interpreters that offer a proper and correct interpretation of what is being said. And they're used to
precise one that we were talking about before.
Yes, and they're used to international arbitration. So it's very easy to find interpreters for languages that are frequently used. So in the example that I gave with English and French, that was not necessarily a problem, but one can easily imagine other scenarios. And of course, the issue of court reporting. Increasingly, we see use of artificial intelligence in this respect, both for interpretation and for transcription. I'm really skeptical how useful that is, even when the proceedings are conducted in English. But if you have a language that's not widely used, the results can be really disappointing. So I think these are just a couple of the challenges that have come up in these sorts of proceedings.
I see. Do you have a more practical tip on when you have this transcript problems?
What do you mean?
I mean, apart from having engaging AI, I
well,
have
first
been
of
in
all, you have to
proceedings where
record
you would have
everything.
the court reporter sitting later listening into the translation or to the original and then typing everything afterwards, having
Yeah.
two
Well,
court
you always have
reporters.
to. You always have to. So if the arbitration is bilingual, you have two sets of interpreters at least, depending on if you also have a witness who is testifying, let's say in a third language, you might have three on occasion, and you always have two court reporters. So you have
Okay.
recordings of everything that's being spoken in English on one side, French on the other, in my case, and then you transcribe everything. So you have two transcripts, and the court reporters have to work together with the interpreters to make sure that everything is aligned, and together with the parties. So as you can imagine, there's a lot of work that goes into this and a lot of time and money.
Yeah, and for the teams also to be following up with all the transcripts.
Yeah. Yeah.
Maybe we open the floor now to the panel as a whole, and I will maybe ask for your views in a couple of broader issues. In your view, in each one of you, what is the most challenging aspect of conducting arbitrations in different languages? Or one language that is not the one that you're most comfortable with, like Galina said, like maybe not English, maybe not your native language, but a third or fourth one. Would be the different approaches to advocacy, the interpretation, the deliberation, the award drafting. What is the most challenging for you and that you encountered whenever you're working in a different language, in a third language? Maybe Carita can start.
Thank you. I will paraphrase also Galina and say, I think we are best used to drafting and operating in English. I'm sure that I do it better than in my, so to say, two native languages. I'll be very brief because as the other panelists said, there is a wealth of matters you can address under this topic. But if we take deliberation, I do think that there is a great advantage in deliberating in the language of the award and the language of the proceeding, even if everybody on the panel has a common native language. I've encountered that often in Sweden, where we're all native Swedish speakers, but the proceedings are in English, and we will still deliberate in English because it seems to pick up the proceedings better. I very much liked that Juliana reminded us and reminds everybody of the importance of thinking through, not only in multilingual proceedings, but even in ones when there are witnesses who speak other languages, exactly how you run the interpretation. And I also like the fact that you questioned that simultaneous translation is often better, because if it's not really good, and especially if you speak the language of the witness, it has even happened for me in an Eastern European arbitration where the interpreter was massaging the responses. I actually had to interfere, which of course you don't do it lightly, but you said that was not exactly what was said. I'd like to add one thing which actually doesn't concern any of us, but sometimes when you think of the restraint that your co-arbitrators must exercise if they are native English speakers. For example, when you draft the award in what I would call continental English, that we all speak more, or we speak some sort of continental English, and you, for example, have an Englishman, an Australian, and an American as co-arbitrators, I am impressed by the restraint they manage to exercise in accepting your continental English as the standard for the award. I know this is more like anecdotal, and not, but I really think I often admire them for exercising that restraint. Thank you.
I would say that is not, well, I'm not so sure if this is the experience of all panelists, but I've experienced native English speakers that were very much into correcting the grammar and saying, no, this is not the way you say it, or seen it, and some are not so constrained, let's say.
Can I add one more thing, which I thought is important to raise here, and that has to do, I think Anna Karina also was into this, the importance of looking holistically at the language and the legal culture. I think one of the most challenging things, for example, if you're a civil lawyer, and then you have all US or UK counsel, and everything of the civil law, which is the applicable law, is translated into a perceived English conceptual world, and it doesn't make any sense. It really doesn't make any sense. You read it and you said, well, yes, maybe the words are correct, but this is not how you interpret or even translate civil law into English. And there, I think that we as arbitrators, even with the risk of somebody thinking we're siding on some side, we need to interfere, because sometimes it is just not intelligible what you get out if you get an English or US interpretation of, let's say, some of the Eastern European laws that sometimes have been influenced by many other legal systems. Thank you.
Carita, maybe to add to that, that was exactly what I was thinking about when Vanessa asked the question about the major challenge working in multilingual cases. So it's exactly that. It's understanding the different cultures and then interfering, but in a way that you still maintain neutrality. I think this is really the art. And maybe there are sometimes even scenarios where you can make the parties explain what they really mean instead of explaining yourself as the arbitrator. So you would rather ask a question, but of course with a lot of caution to avoid any kind of perceived bias. I think this is really the art for people working in these kinds of cases.
Galina, do you have the same view?
You know, like what are the challenges when we work in this environment? I think, you know, like humanly, sometimes working again on a third, fourth, whatever, like language, it just requires you on your side more concentration efforts, you know, like especially during the hearing, and obviously if you're a sole arbitrator or the president, it just, you know, like your brain has to work more, you know, like again, we are more, you know, like certain information just flows into us, and I think like we don't even think in which language we understand, we just understand it, right? But there are moments when it's like, so it's like a true foreign language for us, then you have to concentrate more, and then sometimes it's a little bit more tiring. And then in terms of like style of drafting the word, I don't think that style of drafting is impacted by the language, you know, like what is the choice of language. I think it's, you know, like we have our own styles, we have our own way of thinking, you know, like the way of reasoning or the style of reasoning will depend, you know, like on the circumstances of the case, how the parties pleaded the case, how you discussed the case, the structure with your arbitrators. So, you know, like again, in terms of drafting and approaching the drafting, I don't think the language makes the difference. It's rather, you know, like your understanding of facts, of law, of your understanding of how the law should be interpreted, or the facts should be trusted. Well, this would be my observation.
Can I just make a maybe follow up on that? Do you think maybe more the legal culture that is being used in the case influences more than language?
Absolutely. For me, it's that, right? For me, it's that
Yeah.
because, like there's definitely different approach in the common law jurisdictions, like again, England, like Singapore, Hong Kong, you go nowadays, and civil law, like in civil law, we of course have differences, like, I mean, someone from, like a novice, let's say, like from Belarus or from Poland or from Romania, would not necessarily approach the case and plead the case exactly as a German lawyer or French lawyer, but I think like in these civil law systems, like there will be more like similarities in how to argue the case. But once like our civil, like us and our civil law trained colleagues, like when they're exposed to truly international arbitration more and more, when they also become more and more, kind of common law style arbitration sometimes, like, I mean, nobody comes in their first arbitration and say, like, I want a document production, like, I mean, people come to their first arbitration, like, like, again, depending how I like smell the case, like, sometimes I will not even propose document production in the draft PO1. And if another party proposes, because it's like a more experienced counsel, the novice will say like, no, we don't need document production, right? But they will not do this in few more, like in few first arbitrations. And when they understand these are rules of the games, like common law lawyers do it as well as, like people well established in the civil law countries doing international arbitration as a daily business. So, like it becomes a normal paradigm. So it's like more a background, a culture, like legal culture, rather than language, which impacts the style of pleading or the style of writing. Yeah.
I see. Thank you. Juliana, do you have a different experience, or what is the biggest challenge for you?
Well, I think I agree with what has been said so far. I would just add a little bit on it and say that what I found surprising on my end was that drafting an arbitral award and some procedural orders in Romanian was a little bit more challenging than I had expected them. Even though I studied in Romanian, I worked in Romanian in court cases when I was still a lawyer there. But because I didn't actually study international arbitration in Romanian, having to translate concepts such as document production, cross-examination, you end up effectively explaining the concept in many more words because there's no precise equivalent of that in the terminology that we would use in Romanian. And then I think, just to tag on to what the other panelists were saying before me, I think what Carita said in terms of the art of listening, I think that's essential for any arbitrator, because a lot of the times an arbitrator will have to decide a case where the law that applies is not the law in which they have qualified or they've practiced as a lawyer before. So you cannot take it as a given that if that is a civil law jurisdiction in your trade, in a civil law jurisdiction, then the concepts are necessarily absolutely equivalent. There will always be differences. So you have to pay a lot of attention and to really understanding the concepts, to study the case materials, but also to ask questions to the parties, like Carita was saying, to make sure that everyone is on the same page. And then I completely agree with what Galina was saying with respect to the style of drafting. I think it's more a function of the individual than necessarily the legal culture in which they have grown as professionals. And also, I completely agree with what Galina said in terms of this cross-fertilization that we see between legal cultures as we are working international arbitration more and more, and we see increasingly what we would have labeled as common law approaches coming from civil law jurisdictions. So I'm sitting in an arbitration where the parties are coming from two civil law jurisdictions. In the first draft of the procedural order number 1 that I circulated, I mentioned nothing about document production, and the parties came back saying that they would actually like to have document production. So I think we're just we are part of something that's more international in nature, where we are the crossroads of civil law and common law, and it's becoming more difficult to say that we are just purely a civil law lawyer or purely a common law lawyer. Everyone is influenced by everyone around us, and I think that's one of the good parts of working in an international environment.
More
And
hybrid
Juliana,
environment.
maybe maybe to add to that, I mean, giving you the example of Germany and Brazil, two jurisdictions in which I've worked several years, both being civil law jurisdictions, they have a completely different approach to procedure, for instance. So in these cases, it's again important to understand where each of the parties are coming from, parties or even, I don't know, stakeholders in the arbitration, to understand these differences and again, overcome them as far as necessary. So even if you assume that it's only between common law, civil law, that's really sometimes not the case. So there may be huge differences even among civil law, civil lawyers or common lawyers.
Thank you all. I think I will just, maybe before we close, like you to share one piece of advice for practitioners who speak multiple languages and are not able to use all their languages skills at work. How can language skills be strategically used in building an international arbitration career? Anna, Juliana, maybe you can just like a quick response so that we can wrap up.
Yeah, first, don't be sad. They're still useful skills. You'll meet a lot of people from a variety of backgrounds in your practice. So I'm sure there will be opportunities to engage with someone on a much more personal and deeper level just by the fact that you speak their language. And this will help you to develop your network and to develop your career, even though technically speaking, you're not working in that language.
Anna.
I fully agree with Juliana. And I mean, I mentioned it briefly in the introduction. I've been in a situation where I first started off working in Germany, primarily in German language cases, and felt like my other languages could not be used appropriately. That said, using those languages in another professional context at conferences, being a member of associations that are based in other jurisdictions gives you the opportunity to really form meaningful relationships. And eventually that's what enabled me also to then work abroad, join the ICC, join law firms abroad. So it's really an important skill, even if you're not actively using it right now. And if you are in the position that you're looking for another job, I mean, not necessarily anymore nowadays, but mostly still, you find international arbitration teams in the so-called arbitration hubs, Paris, Geneva, London, that may be interesting for you. And again, stay active, even in jurisdictions abroad, in their arbitration associations, and so on and so forth.
Elena.
You know, like I agree with everything what was said before. You know, like there is no place for despair, and I think the reason why you speak or why you learned another foreign language is because, like, in the first place, you are like interested, attracted to it, you know, by the circumstances, by the culture, by movie you've seen. I don't know what it, you know, like, so I think like in the first place, it's not an arbitration driven interest, but something deeper in you. And this is just so fun to cultivate that, right? And continue to improve that language, you know, like having access to people, you know, like in professional circles, but also in other circles. And it just makes you more interesting as a person. And it's like satisfactory.
Carita, do you have an advice also how people can include their language skills in their careers?
I also agree with everything that was said. I have 2 points, actually. The first one is, I think knowing many languages shapes your personality, and more important, it refines your listening skills. And I think I shouldn't speak about Eastern Europe as much because we have many here on the panel, but I would say that I think that one of my favorite stories often when I speak is when you listen to somebody who was raised and educated only in Eastern Europe, and then, for example, a QC, you really need to understand how the material is presented. And as I think I said when we discussed previously, sometimes things are only said once in a civil law plaidoirie. They say it once and then it's enough, and then there's more repetition often in a common law setting. And you just should have no, how would I say, prejudice against the one or the other. And I think that knowing many languages activates those very skills that you can take in that it comes in different shapes and forms. And I don't mean to hold the closing remark, but I do want to say to my co-panelists, I was hugely impressed to read about all your languages, because I heard when I was younger that it was good, to work in 4 languages and maybe understand and speak 2 or 3 more, but I have never seen such a wealth of languages as I have now experienced on this panel. Okay, so thank you.
Thank you all for your insights. Thank you very much for sharing your views and experiences with us. You've shown us that multilingualism in arbitration is far more than vocabulary, and is about culture intelligence, listening, and connection and relationships. I would like to thank our partner organizations, Europe Pledge and AAA CDR Asia Case Management Center, and the invaluable support in making season 5 possible. We are also really grateful for all the organizations that are supporting us with marketing our series. And for those watching us in YouTube now, the video ends here. Thank you for joining. To see future ARBinBRIEF videos on handpicked arbitration issues, please follow us on LinkedIn and like and subscribe to our channel on YouTube. We would like to hear your comments and feedback, and you can register for our next episode in www.arbinbrief.com. We look forward to seeing you there.